SJC-11850, Commonwealth v. James Allen.
Good morning, Your Honors. May it please the Court, Matthew Soares for the defendant appellant James Allen for his appeal of his convictions for second-degree murder and firearms convictions. This case is here from our petition for direct appellate review from the appeals court. I'd like to first begin by discussing some aspects of the evidence that I may not have gone into as much in the briefs. This was a situation here where one side was outnumbered the other side. The side with of my clients only had 5 people that were there. This was a house where my client his mother lived in the house, and across the street was a large apartment building where the decedent lived with several other people, and 10 people were named in the transcript as being from that other side. And a neutral witness who lived next door to my client's mother's house said that this was a situation where the other side, the 20 Homestead group, had the upper advantage because they were outnumbered. They outnumbered the other group, and there was a large crowd gathered around egging on the fight situation. And this was an instantaneous situation where my client had to act to defend his friend.
Mr. Soares, at the trial, was there any, I take it that this is leading up to the defense of another instruction. I mean, it's sort of the background for that. So
Yes,
I'm
Your
wondering, at trial, was there any disagreement or question raised by the prosecution or the judge that an instruction on defense of another was appropriate? I mean,
No.
that was always in play. Is
It
that
was
right?
never even contemplated by any of the parties at trial.
That it wouldn't be given.
Right. They didn't even begin to discuss that. So as I wrote in the reply brief, it's waived, and if it's not waived, it is frivolous to even argue that an instruction should not have been given. Along those lines, I was struck during research for the case by how few cases there are with any factual scenario remotely resembling this, because I submit that those cases, the defense of another defense is successful, and they're not even appealed. You find cases where the instruction was denied, and most of the time it's clearly should have been denied, and there's not even a case with a situation close to this.
Now, you agree, well, I shouldn't say, do you agree that defense of another is appropriate only when deadly force is the only thing that could spare the life of the third person?
Yes, I agree, Your Honor.
And so, if that were told to the jury, that would be an appropriate instruction. If the jury were told that a defendant may use deadly force to save the life of another only if that is the only way that he can do so.
In the context of this case, where the judge said, well, there were 2 major problems, but as far as the judge said that the defendant had to avail himself
Right.
of
Well,
other
I understand.
available.
That's, I guess, my question is, why do you think that the judge's statement, the person, and I'm quoting, the person may not use force in defense of another unless he has availed himself of all proper means to avoid physical combat would be understood by the jury to mean anything more than it has to be the last, deadly force is the last recourse, as opposed to your view that they would understand it to mean that there was a duty of retreat?
Two major reasons. The lesser one is that combat had already begun. It's confusing to the jury. That's where the genesis of the whole problem is, that the self-defense instruction does not fit in a defense of another instruction, especially in this situation. It highlights it. It's a perfect storm of a situation where.
Well, some of it doesn't fit. I mean, I don't think you disagree that
Yes,
some
Your
of
Honor,
it does
absolutely,
fit.
yes. The part about having to avail himself of other available alternatives. There's already a fight beginning, so he can't avoid combat. So that right there is confusing. That's the lesser point. The greater point is that it completely is conflated with the excessive force manslaughter provision and removes that because failing to avail oneself of other available alternatives is basically the same thing as using excessive force. He could have done something else, and what he did was excessive. Those are basically the same thing. So how is and the judge specifically instructed that there are three ways. He said, if you find that he did not avail himself of other available alternatives, then that's murder. And you don't even reach the question of excessive force.
He did give he did give a manslaughter instruction, though. But
Yes, he did,
Your
but-
point is that, given the one that you are referring to, the manslaughter one, it just would be at best totally confusing how they work
At
together.
best confusing. I would argue it instructs them not to consider it. It's how do they just come to the conclusion, okay, yeah, he could have done something else. I don't know what they might have thought in these facts. Shot maybe in the foot, was a better aim, but
Well, you
something
could-
with the
you
gun,
could
just
try
pulled
to-
out the gun.
You could try to overpower let's see, which one would it be? You try to overpower
Mr. Williams.
Mr. Williams.
Right, so if they find that something, right, if they find that, then, okay, he didn't do that, so it's murder. And the language about excessive force manslaughter, they don't reach that because it's basically the same thing. They're confused about which to pick. And I think, given the facts, if this case were not if the evidence weren't so close, then it could be an argument that it was harmless error. But in this case, there's so much evidence of innocence that he successfully defended his friend because he had to, that his friend was about to be stabbed in the chest, and that if he hadn't fired the shot, his friend would have gotten stabbed. So this is a perfect case for showing how that instruction is confusing and takes away excessive force manslaughter.
Excessive force manslaughter applies when a defendant would be justified in using some force, but not deadly force.
Yes.
Right.
And that a little bit, I mean, but that's different from saying deadly force must be, I mean, at some level you can say that's always the case whenever you tell a jury deadly force must be the last resort.
But in this situation where the judge included this provision to avail oneself of other available alternatives, that is not the language that is in the seminal case on defense of another, Commonwealth versus Martin. And it is not in the current model instructions from this court. They came out in 2013 after this trial, but the instructions, the model instructions that were in force then, the 1999 instructions, don't have any provision like this about having to avail oneself of other available alternatives.
I'm looking at the new model instructions. The Commonwealth must prove beyond a reasonable doubt that the defendant did not actually believe that the other person was in immediate danger of death or serious bodily harm from which the other person could save himself only by using deadly force. So it does say only by using deadly force.
By using deadly force, which is from Martin. If you see the exact language of Martin, That's all that's required, and it does not have the problem of conflating that language with the excessive force manslaughter. Martin says that the two clauses, Clause A, that a reasonable person in the actor's position would believe his intervention to be necessary for the protection of the third person, and B, in the circumstances as that reasonable person would believe them to be, the third person would be justified in using such force to protect himself. Such force meaning whatever degree that he used, if they find that justified. Having to take this extra step of contemplating what else could possibly be done, that is in the law, but that is excessive force manslaughter. It's the same thing. So
Is there any, I don't know this, but is there any case which discusses the use of the, well, if you just have a straight self-defense and then excessive use of force is obviously a manslaughter, so one is not guilty, the other is guilty of manslaughter. Is there any case that deals with that, the counterpart in the
self-defense context.
in the defense of another context?
There are cases where there is, of course, excessive force manslaughter. I think the issue is that those situations are quite different when someone's defending oneself as opposed to defending
Yeah,
someone.
I guess what the question I'm raising is, and I really don't, I haven't thought about this before, but whether there is in this whether the excessive use of force manslaughter alternative is relevant when it is defense of another as opposed to self-defense. Because of the point that Chief Justice Gantz is making, that the application of defense of another depends on whether or not you had to use deadly force, at least in a context like this.
So you're saying that the excessive force manslaughter should not even be
I'm just raising it. I'm not aware of a case where that's actually been discussed, but there may be some.
I'm not aware of that, Your Honor, either. Are you saying that there
I'm
could
not saying
possibly-
anything. I'm
Okay,
just kind of
sure.
speculating.
I'm not aware of such a case, Your Honor. In a defense of another situation, the defendant would always have, that would be an available option, would be excessive force manslaughter.
Right.
And that's something that does track the self-defense instruction, and the self-defense law is the same on that. It's
So
just-
do you think that, I mean, your other, and I thought this was your major claim, but perhaps not, was that, or is that, the instruction about retreat in this context being erroneous?
Yes, that's the first point. And before we even get to that, the instruction that was given was confusing and ambiguous as far as who has the duty, who can retreat. The exact language is it's the judge instructed at transcript 9101. The person claiming defense of another may not use force in defense of another person until he has availed himself of all proper means to avoid physical combat. A person who reasonably but mistakenly believes that the other person is in imminent danger of serious bodily harm or death, and that he has used all proper means to avoid the use of force, may still use deadly force to defend the other person. It's confusing to me to this day when I read this. Who is he? Because this is taken from a regular self-defense type of instruction where there's only two people, so there's no ambiguity there. Now we have three. So this is a situation where the person being defended is already in combat. That's already been decided. That's determined. So how is that relevant that they're saying now the defendant has to avoid combat that's already begun. I go into that more in my brief. I see my time is running short.
Doesn't the Commonwealth actually concede, or at least suggest that that means that the sentence isn't vague, because what it really means, and it's clear because of the, that it's the person in the defendant's position, that is the defendant here, was the one who should avoid physical contact. That seems
Yes,
to be, and they think that's fine.
I disagree with that interpretation entirely. In my the reply brief, I specifically addressed that point, Your Honor, on why I think that argument is incorrect.
All right, thank you.
Thank you very much, Your Honors.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Amanda Teo for the Commonwealth. With me is Assistant District Attorney Jennifer Hickman, who is a trial prosecutor in this case. We are asking this Court to affirm the defendant's convictions. I agree with my brother here that we must start with the facts, and that any consideration of the instructions divorced from the facts simply wouldn't make sense on this occasion. This was not a situation, as my brother proposed in his brief, where you have a good Samaritan who comes in medias res to a violent confrontation between two people he does not know.
But Ms. Teo, you do have a lot of confusing testimony, and if one gets an instruction, if there's any reasonable view of the evidence that would warrant it, I mean, maybe it's completely unconvincing, but there certainly was evidence that would suggest there's a lot of going back and forth, and I mean, it seems to me that that a fair look at the trial and at the position that the attorneys and the judge were taking was this instruction should be given.
I think there was that the trial prosecutor properly thought that where it's a close case, it would be wise to err in favor of allowing the instruction or not objecting to the instruction being given. However, when this court and any reviewing court takes into account whether or not an instruction was proper and undertakes an analysis of prejudice, certainly this court looks at
That's
whether
a
or
different
not
question, but I thought you were arguing it shouldn't have been given at all.
Sorry, Your Honor. I mean to clarify, that whole section is just meant to set up the fact that even if there was any kind of ambiguity or lack of clarity in the instruction that was given here, the defendant was not prejudiced because he was not entitled to the benefit of this instruction in the first place. Certainly in my brief, it made sense to put that as the first section. However, what I mean to suggest by that—
you have to give an instruction in the correct, it has to be a correct statement of the law. You can't say that even if it was wrong, he's not prejudiced because he wasn't entitled to it. That doesn't make sense either.
Your Honor, I would point this court to Torres and Curtis, amongst other cases in which this court has repeatedly undertaken that precise kind of analysis, where even if an instruction is incorrect, whether or not the defendant was prejudiced by that incorrect instruction depends upon whether he was entitled to that instruction in the first place. But nonetheless, addressing Justice Hines, your question, the Commonwealth's position is that this instruction was entirely correct.
But let's go to that just for a moment. I'm trying to, let's assume that the defendant subjectively believed that Mr. Buchanan was in imminent danger of serious injury or death, and that belief was objectively reasonable. Isn't that okay?
That would only be one part of the Martin formulation. The other part of the Martin formulation would require someone in the defendant's position to reasonably believe that deadly force was the only way in which he could protect Mr. Buchanan from that harm. And that's exactly what—
So does that mean that this person, as instructed here, has to avail himself of other available alternatives? What does that mean?
Absolutely. I think that is implicit in the second prong of the Martin instruction. But not only that, even—
what does it mean?
It means that where you can shout, where you can use words—
Stop stabbing him. Don't stab him.
Stop or I'll shoot, then you're not entitled to use a gun and fire. And I think as a matter of sound practical policy, That is what this court, that's the law that this court should endorse. But not only that, I think that's implicit in the common law defense of another.
Okay, go ahead, sorry.
Sure. In the defense of another theory, as it stands, there is a requirement of reasonableness, of proportionality. We understand that any use of deadly force arises only because of necessity and must end when the necessity ends. We understand that that theory is only available to protect someone and not in order to punish or to retaliate. And so I think all of these principles go to why, just as a standalone proposition, that instruction makes perfect sense. And in fact, is a very clear articulation of principles that are implicit in the defense of another instruction. And here...
Where does it come from? Because I don't really see it in the model jury instruction so much.
I think you're correct, Justice Cordy. It is not so much explicitly in the model instructions as it is a derivation of the principles that must necessarily adhere in the defense of another defense. But not only that, in the situation here...
You agree that there is no duty to retreat by the defendant here?
Absolutely, Your Honor. And at no point did this judge say to the defendant, or to the jury, that there was a duty to retreat. The judge never says retreat. And in fact, as the appeals court said in the Hakala and the Sullivan case, it would defy logic for a jury to understand the judge's instruction here as requiring a duty to retreat.
So to avoid physical combat does not, in your view, suggest leave?
That's correct, Your Honor.
Just
because
do nothing?
To avoid physical combat, simply, when someone is coming to the defense of another, that is necessarily an intervention. That cannot mean that that person has a duty to retreat. It simply doesn't make sense. A jury is assumed to apply common sense to instructions. And I would suggest that this court undertake the same kind of analysis that the appeals court did in Hakala and Sullivan, and note that this theory of retreat simply wouldn't make sense given what the jury heard in this case.
I was confused.
Well, how do you avail yourself of all proper means to avoid physical combat?
Right.
Again, if words can end the altercation, can protect the person from harm, either by saying stop, don't shoot, or saying, Mr. Buchanan, run, then that should be used in this case. Now, I'm not saying that whether or not that was an available alternative. That was for the jury to decide. Where a jury decides that that's not an available alternative, that's for the jury.
How was this argued by the prosecutor in closing?
That's a very important question, Your Honor. The prosecution never went under the theory that this was a use of excessive force or that he could have done something other than shoot in protection of Mr. Buchanan. The prosecution's theory from the get-go was that this was never, that the defendant never intended to protect Mr. Buchanan. What he intended to do was to use retaliatory force. And that argument was advanced through the proper use of the evidence. The evidence was that Mr. Buchanan and Mr. Allen showed up together on Homestead Street. Mr. Allen was already armed at the time that he showed up. He then helped to instigate this fight. He saw the entirety of the altercation from start to finish. He saw this escalate from what is, everybody agrees to be a silly argument, to a half-hearted fist fight, to then a half-hearted knife fight. And yet, he took out a firearm and shot the victim, even though Mr. Buchanan was doing fine on his own, escaping the half-hearted parries of Mr. Williams. Not only that, at the end of this entire encounter, Mr. Allen says Mr. Allen says at the scene, "You don't bring a knife to a gunfight." If that is not the best evidence of murder rather than defense of another, I don't know what can be.
Does the record indicate how long the gun had been, quote, out?
It does not, well, the testimony was that at the time, the testimony in light most favorable to the defendant was that Mr. Allen took out the gun from his waistband at the same time as the knives were taken out. But certainly he had the gun in his waistband the entirety of the time. He was standing on the porch or on the sidewalk in front of Mr. Buchanan's family's house and witnessed the entirety of the altercation. So this was an individual, like the defendant in Barboza, who saw the entirety of the interaction and had the opportunity to assess the status of the fight before intervening.
Yeah, I don't get why that, I mean, since we have many different accounts of what was actually going on, why would it have been entirely clear to him from being there as to what exactly was going on in this case? I mean, there's a question of whether a knife was pulled, a question of whether the knife was broken. We've got many different versions.
The people saying he's got a knife and screaming, and you're sort of saying, well, I should realize this is a half-hearted fight? Is that what you're saying?
Absolutely, Your Honor. This was a situation where this is not a Good Samaritan who happens upon a fight in medias
It's a
res.
good Samaritan, but there's a...
Sure, and that's actually why I think, as a matter of logic, I began where I did in my briefing. Because
You're
even
saying
in
only
light...
Good Samaritans are entitled to a defense of another instruction? Is that your point?
I'm
I'm having
saying-
trouble understanding where you're thinking the Good Samaritan, is that the model for the defense of another, somebody who's completely disinterested and just comes upon a scene and only that person gets the defense of another instruction?
No, not at all, Your Honor. What I'm saying is that the defense of another instruction encompasses all of these possible scenarios, but the one that the defendant is putting forth is that if the defendant's argument is that if this court would agree with the Commonwealth that the instruction here given was correct, then that would dissuade Good Samaritans from acting. And I don't believe that that would be the case
Well, that's
because
the
this is
amicus
not a
point.
Good Samaritan.
Isn't that the amicus point?
The amicus point is that if you had terrorists on a crowded and moving train from which nobody could escape, then if this court endorses the Commonwealth's position, then those heroic interveners would be prosecuted for murder, and that's simply preposterous. That is in no way what we're arguing. Going back to the proposition of what we are in fact arguing, it is that in this situation, where you have a defendant who is in the exact same position, so to speak, as the person who he's coming to the aid of, who has access to all of the same information that Mr. Buchanan does, when a jury is assessing whether someone in his position would reasonably believe that Mr. Buchanan was threatened by deadly harm and that deadly force was thereby necessary to protect him, that you have to take into account where Mr. Allen was during the entirety of this altercation and what information he had available to him. That's certainly what this court did in Barboza, which I would argue is quite similar to what went on here. There, as here, the defendant and the person who he was allegedly coming to the aid of were at the same location at the same time. The defendant saw the entirety of the episode that escalated to a deadly confrontation. The defendant here was on the porch just mere steps away. He knew exactly what this confrontation was all about. He saw that the parties were not really into this. He saw, as everybody, I think, agreed, that they barely made contact when this was a fist fight, and they made no contact whatsoever when this became a knife fight. He also saw that this was a public street that Mr. Buchanan was very familiar with, and that Mr. Buchanan had available to him a means of egress from the confrontation just by running in the direction of the next street over or by running into his mother's house. There's testimony from Mr. Buchanan's mother herself that the door of her residence was open. All of these avenues were available to Mr. Buchanan, and if Mr. Buchanan was
Let me ask you about that. Let me put aside this case, okay? Let's assume something similar, different case. Person goes to the event, and his friend stupidly gets into a fight with the other person. The other person pulls a knife, and the person who was ultimately stabbed could run, but doesn't. and the other person then is about to stab him in the heart, can a defendant do it even though the defendant himself could not have used force because he had a duty to retreat?
If, absolutely, Your Honor, if the testimony was that the other person was about to stab the third party in the heart, here, the evidence, even in light most favorable to the defendant, was that these two men were no closer than an arm or an arm and a half lengths apart, and that at the time the shot rang out, the distance between the two men was actually growing rather than narrowing. On those facts, which I think are very different from the one Mr. Chief Justice proposed, there is no right of defense of another here. Certainly, we would say that if Mr. Buchanan, that a reasonable person in Mr. Buchanan's position in that situation could have availed himself of
I
an
guess
opportunity
my question is a little bit
retreat.
different. Let's assume that the victim could not have used force in self-defense because he had a duty to retreat, which he did not act upon.
Sure.
Can a third person?
Yes,
then-
Your Honor, and my brother counsel has pointed out that this is not a jurisdiction that embraces the alter ego rule. A mistaken but reasonable belief would have been fine in the situation. However, as I set forth in the first section of my brief, this would not have been a reasonable belief given the facts that are here. At the end of the day, Your Honor, I think it bears recalling that a jury here would not have been confused as to what the scenario was. This was a situation where the defendant came armed. He came with Mr. Buchanan. He was there and instigated this fight. And then he shot the victim in the back and then said, "You don't bring a knife to a gunfight." If those facts do not support a conviction of murder, and if on those facts, a jury would not be entitled to believe that there was no desire to protect a third party here, but rather a desire to punish or to retaliate, then there can be no situation in which the evidence would support a conviction of murder in this type of scenario.
Thank you.
Thank you.